Morning, Judge. We're approaching on Mrs. Troy Britton. This is the one that, oh, you weren't here yesterday, Judge. Judge Jackson was here yesterday. We were trying to do something, but I asked to bring my client here so she can know what's going on.
So, Judge, the original approach yesterday, while Judge Jackson filled in, was the man jurisdiction requested an extension of 2 days, which she granted because it's 2 days and typically do that. But Ricardo wanted the accused to come to court so that it could be a more formal understanding of what's happening. And during that time for this morning is Ricardo's not telling me she is wanting to have a bond set by the court. State as opposed.
Yeah, this is the one where she's like 17 and she's got already like
she's had 7 charges,
yeah.
2 of them
She's
failure.
19, Judge.
okay, 19, right? Yeah, sorry, I can't. Just you scare me, man. I can't. They're all very violent cases now. You know, you're wanted at state for another. You know, sorry,
Judge, if I may,
Sure.
in talking to my client, you know, she's made valid points to me, and of course, I'm just.
I know you're advocating for your client, and I'm never going to begrudge anyone for advocating. It's your job, I know, but you're 19 years old. You've got
7 prior offenses at just 19. That's not a record. That's a pattern. 2 failure to appear charges mean she's already skipped court before. And judges don't forget that. Here's the legal reality. A failure to appear is not a mistake. It's a separate criminal charge. Once you lose a judge's trust, getting bond becomes much harder. So tell me, how many chances would you give? Type 3 strikes or give her a break in the comments.
7 priors already. You're wanted out of another state. There are multiple aggravated assault cases. You've got 2 failure to appears. At some point, we have to say when. And now's that point. You scared me, really. I don't want anything else to happen. So,
So the extension was originally granted by Judge Jackson out to the 24th.
I'm not doing any more. If they don't come here by that point, she gets released. Okay? All right. Thanks.
Thank you, Judge.
Thanks, Your Honor.
So, Ms. Young, come on up.
Good evening, morning.
Don't look at his computer.
Sorry, I was trying to get the time from
How's jail?
evening. So
How's jail? Shh.
treating us beautiful.
You know, we can't get you to come. We can't get you to appear.
Well, what happened was this time,
No, but there's always an excuse. It's really easy to just pick up a phone and call Josh. How hard is that? You know, that's all we literally ask you to do is remain in contact with your lawyer. That's all you got to do.
yes, sir.
We've repeatedly tried 4 different times. Your lawyer's asking me to let you out to get in this program, but I know if I let you out, you're just going to
No, sir.
take off.
I'll do the program. That's not the problem, sir. Honestly, with the phone situation, that's how he has a whole different number since last time I came. I don't even have that number anymore. And with the transportation part, I don't have a car. So the way I move around is either using the bus or my feet, sir. And last time that I did come, I came on my own. No one told me to come. No one called me. I knew I ended up missing it. And
This is the pivotal moment of the hearing. Rather than denying release outright, the court is considering a conditional bond with GPS monitoring. Legally, that's significant. A GPS monitor allows a defendant to remain out of custody while giving the court a way to verify compliance and location. In other words, the judge is balancing 2 competing interests: public safety and the defendant's opportunity to participate in treatment and court programs. Emotionally, you can hear the frustration in the judge's voice. After multiple missed appearances and repeated communication failures, trust is clearly running low, yet the court is still willing to offer another path forward.
Can you tell? If you turn yourself in,
I
that
came
would
to
make me
court.
very happy. But if you just got arrested and that's why we have you,
Sir. No, sir, I came to court.
Young, she's on the jail doc. Last page, I think. Fool me once, shame on you. Fool me twice, shame on me.
I'm not trying to fool anybody, sir.
Did Judge give you
Are you able to look that up for me?
It's okay, yeah.
Okay.
The date that
Is it on there? Because it was like 2 days, yeah, like it was 2 days after my court date, I came. No one called me, I just knew I missed it and I didn't have a ride, but I made sure to get up there because that's how I got my date reset the first time.
Looks like the booking date was the 12th, Judge, but I don't know. That's all I can see from my side.
That's when I came to 12. I've been here since.
Where did you come to?
Sorry?
Where did you go to? Did you turn yourself in the jail? Is that what you're saying?
Sir, I went to the Franklin Street, if I'm not mistaken, Franklin, 1200 Franklin, where all the court is at. Where I was supposed to go the first time. 1200 Franklin, if I'm not mistaken.
If it was on Sunday, though, was it on the weekend that you came?
Honestly, I don't even remember what day. This time? Yes, sir, I can't.
Let me, you know what we could do is we could do this, is that if we're going to do this, you know how we do that release that we release to people?
Right.
Something like that. So we know that she gets to the P180 place. Where is it? Where did they do the interview? Do you know?
I guess because it's not like an inpatient facility, would it be different if it's?
Where does it happen? Do you know? Do you know where the interview happens, Josh?
I'm not sure, like physically where it is, the P180. I'm checking the state though, because I guess she wouldn't be released to that program. She'd just be released and have to.
Do you have a date already for it?
Sorry?
Do you have a date for it?
There's like a way to book it online, but they said that you have to send the contract to PTI, P180 contract. So, which I think is what we have now. So I think we should be able to schedule it now.
Okay, so let's do this. Schedule it, get a date, and then I'll put a GPS monitor on her prior to release.
And there it is, the GPS monitor. That's the court's way of saying, I don't fully trust you, but I'm still giving you a chance. Legally, this is called conditional bond. Not freedom, but control freedom. A GPS ankle monitor is basically freedom with a leash. No personal recognizance bond here. So the question is, would you wear a tracker just to get out of jail? Or is that too, big brother?
I'm not going to do this again. You ever take off on me again, I swear on everything that's holy, that'll be the 5th time. Do you understand? So I'm not giving you a PR bond now to just wait, get a date. We'll set it for like the day before, and then we'll give her a PR bond with a GPS prior to release. The instruction is she goes directly to get the interview done, and then we'll go from there. But I'm not going to continue to play this game.
But I'm not playing a game, sir. It's been cold. Like, what do you expect? It's been 20 degrees, sir. 20 degrees. You know how hard that is to actually stay.
Your finger's so frozen that you can't make a phone call?
Sir, I just got the phone. That's what I'm telling you.
If you need resources, we can give it to you. If you need a phone, if you need a tablet, if you need food, we have resources to give you. But you take off, you don't call, you don't come to court. So what are we supposed to think? And we just can't keep, I've got 4 different times. I can't continue to do the same thing.
We'll get the schedule.
All right. Do it and we'll see. Okay. What time does court start, sir?
Court starts at, I just read the sign, 8:30, sir.
What time did you get here?
I got a felony court at 8 o'clock, sir.
Oh, you had felony court today?
Yes, sir. Excuse my absence, sir.
It's okay. I mean, if you had felony court, then I'm not going to ding you.
Or 183 Judge Lang or something like that. Just been appointed January 1st.
So the one that's in 13 is getting transferred here? You've now picked up your 3rd case.
Yes, sir.
You were not, don't say anything. You're charged with possession of marijuana again. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
Your Honor, which possession case are we doing PC on, the one ending in 562 or the
Let's
962?
do, yeah, 562. And then we'll do the other one right after.
Okay. On January 6, 2025, the officer conducted a traffic stop on the 3100 block of West Little York Road for the defendant's vehicle having a defective passenger tail light. The officer made contact with the defendant, the driver, with a passenger. The defendant gave permission for the officer to search the vehicle. The officer observed a clear bag of green leafy substance, which emitted an odor of marijuana, between the passenger seat and the center console. The defendant admitted the bag was his, and the substance was known to be marijuana.
50.4 grams of marijuana. That's almost 2 ounces. And in some states, that's close to trafficking levels. Here's the key detail. This hearing ended with a clear message from the court. Accountability matters. Throughout the proceedings, Judge Fleischer repeatedly emphasized the importance of showing up, following bond conditions, and taking legal obligations seriously. The court reviewed multiple cases, addressed concerns about misappearances, considered treatment options, and warned the defendant about the consequences of continuing down the same path. What stands out most is the judge's effort to balance enforcement with opportunity. Even while expressing frustration, the court continued to explain expectations and provide a roadmap for compliance. Ultimately, this case highlights a reality seen in courtrooms every day. Second chances often come with strict conditions, and keeping them depends entirely on the choices a defendant makes moving forward. If you found this case as intense as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more.
A small bag of marijuana in the driver door compartment. The officer detained the defendant, and the weight of the marijuana was 0.289 ounces and was known to be marijuana based on training experience.
Stops today, Mr. Martin. I will test you 45 days from today. And if you test positive for marijuana, I'm going to revoke your bond and put you in. Do you understand?
Yes, sir.
No more smoking marijuana. I'm making it a condition of your bond. Do you need a court-appointed lawyer, sir?
Yes, sir, for right now.
Okay. I'll have you fill out an application. If you qualify, I will provide you a lawyer today. And let me make one more thing apprise you. If you pick up a fourth case, I'm going to go nuts. Do you understand, sir?
Yes, sir.
Your attitude is that like this is a big joke, but I don't know why you're laughing. It's not a funny matter. And, but
I have the right to speak.
no, don't.
Yes, sir.
You have the right to remain silent. I have a bunch of DAs here. Whatever you say, they're going to try to use it against you. I'm just trying to impart to you that a third case, it's not a happy thing. Good morning, Mr. Chappell. Do you have a lawyer today?
Sir,
Do you have a lawyer today?
I'm trying to get a court appointment.
I'll have you fill out an application. I'll see whether you qualify and we'll go from there.